I am Britt Berner, and I'm here for part one of a four-part series about COVID and estate planning. Our first part today, we're going to be talking about durable powers of attorney and advance directives, healthcare documents for people of all ages. We are going to follow that up with a segment on Thursday. What impact does the closure of the surrogates courts have on the debate over the need for a living trust rather than a last will and testament? And that is going to be with Nancy Berner. Then next will be guardianship proceedings during COVID-19 next week. And then on Thursday of next week, Nancy will be back again joining us to talk about Medicaid in the time of COVID-19. And I may be there along with her on that one. So what we're talking about here, we came up with the idea to do this because all along throughout this time, we've been talking about COVID and we've been talking about how it's created our clients to think differently, potential clients, new clients to think differently about their planning. And it's also changed how we think about the planning that we are recommending to people and how we're advising. And so what we're trying to do is show how COVID-19 specifically, but more generally a pandemic or a big upset as this has been for all of us with all of the closures, how that's going to affect how we advise clients going forward. So that's what we're here to start today. I think COVID has taught us all many lessons. I mean, for some people, it's how to bake sourdough bread. It's how to make banana bread. I did that for the first time when this shutdown began. We've learned new dances. We've learned our capacity for exercise. We've learned our capacity for compassion for others and supporting our communities. And we've learned how to do it in different ways because we've been home and we've had to improvise. And with all of that in mind, as elder law and trust and estates attorneys, we've really had to think about how this is impacting clients and what documentation they really need as things go on in case something like this happens again or something personal to them that has similar effects. So really, we're talking about these uncharted waters. And if there's anything that COVID taught us beyond the bread, beyond the dancing and all of these other things we've learned how to do, we've learned that things can change on a dime, and that when these unknown or uncharted waters come along, that the best thing we can do is be prepared to the best of our ability. And when we're talking about estate planning, the most basic documents of estate planning that we're discussing are the Advance Directives, the healthcare proxy, the living will, and the durable power of attorney. And these documents are the staples of a good estate plan. And a lot of people think about the will or the trust being the main part of an estate plan. And that is the case. They are very important documents, but the power of attorney and the healthcare proxy are the documents that are going to give you the control as you enter into possibly these times where you have no control. So you may not be able to speak up and speak to the doctors about your wishes, but if you've put into place this team, this team of healthcare proxies, persons that are close to you, that know your wishes, that know what you'd likely choose if you had the voice to say so for yourself, as well as those people who you put in place on the financial side with the power of attorney. If you have people in place, your team in place that knows you and knows what you would want, it's the closest thing that you're going to have to control in a time where you don't feel like you have much control. The team, that's really what I want to hammer home today is who are you putting in place to take care of you if there comes a time where you can't take care of yourself. Now, when we talk about incapacity, we talk about the inability to make your own medical or financial decisions. We're not just talking about a long-term incapacity like dementia or Alzheimer's or some other cognitive impairment that leads you to be able to never come back to being able to make your decisions. It can be a momentary impairment or a short-term impairment, such as being very short-term, being under anesthesia for a surgery, as we've seen in COVID, being on a ventilator for a period of time. People are coming off those ventilators and can return to consciousness and return to being able to make their own decisions. And we're also talking about people who maybe, while they're not as quite as severe as the ventilator, but they are in a hospital, they can't have guests, they're on some medications, they're a little groggy, they're exhausted, they're fighting a virus, and to have others in charge and helping them get through these times and make decisions for them and make sure things are taken care of is going to be invaluable. And this has happened to people of all ages. You know, that's the other thing that COVID-19 has showed us, is that none of us are invincible. And so I think it's important that a lot of younger people think that these advance directives, the power of attorney, that these are documents for the elderly, but they really aren't. They're documents for all of us, and they're important for all of us. And we may draft them differently when we're younger than when we're older, and we may have different people to name that we want to make these decisions for us, but in the end, they are important documents to always have. Along with that, I'll say they're not what I like to call one and done. The people that you choose when you're in your 20s to be your healthcare agent or your power of attorney may not be the same person you would choose in your 30s, your 40s, your 50s, and on. So these are documents that need to be revisited over time, just like any of your estate planning documents, to make sure that it is up to date with the way you're feeling at that time. And that is going to change as you get older and as your life changes around you. So when we talk about advance directives specifically, we're talking about the healthcare proxy and the living will. The healthcare proxy is the document that says who makes your medical decisions for you if you are unable to make them for yourself. So it actually requires that you be deemed incapacitated by a doctor and unable to have those conversations, in which case this person can step in and do so for you. You can have one person at a time. So if you have 2 children, for example, you'll have to choose one and then the other. If you have 4 children, you can choose them all in succession, but again, not duplicate. And you're specifically going to want to say in that document if your agent under the healthcare proxy has the right to make decisions on your behalf regarding artificial nutrition and hydration. And the statute actually calls for you to say that that person knows your wishes regarding these means. That brings me to the next very important point. It's one thing to put in a document, my daughter knows my wishes and she can make these end-of-life decisions for me. But it's quite another to actually have that conversation with your daughter. Talk to her about the circumstances in which you may want to have certain interventions, antibiotics, dialysis, cancer treatments, cardiopulmonary resuscitation. These are all a feeding tube, another example. These are all the different types of interventions that we're talking about. And how do you feel about those? And in what circumstances would you want these means used, and which circumstances would you not? Now, you're not going to be able to describe the exact situation to your daughter in my scenario, because you don't know what it's going to be. You're signing this in advance of needing it. But if you start to have these conversations and you start to give these examples, then the person you name as agent is going to be better prepared to make the decisions for you at the time that they need to, with the knowledge in their head of the kinds of decisions you would make if you could have been there. And it's the closest we can get to substituting for your own decision making. So it's really important that you do that. Another reason that it's really important that you do this in advance of needing it is because you never know who's going to be available or what the circumstances are going to be if you do end up in a facility. So I'll give an example. Back a very long time ago, probably the first time I was ever admitted to a hospital, I had to have my appendix out. And right as they were wheeling into surgery, I told them to wait a second, and I wanted a healthcare proxy. And I knew I needed a healthcare proxy. And this was something I wanted to make sure I signed before I went under anesthesia. But during COVID, what we've learned and what we've heard from stories from those frontline workers is that they're overworked, and if there's a lot going on in the facility and they may not have the healthcare proxies there for you to sign, or they may not have two people who can jump in and be witnesses, or they may not be able to slow down, or you may not be at a position where you can sign it at that point. You might not have the capacity to make that decision of who would be your agent. So it's really important that these are signed in advance and then put away for safekeeping, where the agent knows where they are and they can use it if needed, so that they can act on your behalf. A copy is as good as an original when you're talking about a healthcare proxy. So you could email a copy to the agent you named. You can have a copy on file with your doctors. And then you can also have copies in your home or on your phone. So it's important that that healthcare proxy, that not only do you sign it, but you let people know it exists, so that if you do end up in a facility, it could be presented so the facility knows who to speak with. Now, what happens if you don't have a healthcare proxy? Well, if you don't have a document and you end up in a facility, then the facility has what's called the Family Healthcare Decisions Act that they can fall back on and they can use to make decisions. The problem there is that the person that is the highest up in the hierarchy under the Healthcare Decisions Act may not be the person that you would want to make the decisions for you. For example, a married individual, their spouse is first in line to make decisions. Now, there may be a situation where your spouse is unable to make decisions, would not make the same decision that you would make if you had that choice at the time, or maybe it's a very hard decision about if you should be extended on life support or if life support should be withdrawn. And you may have given your agent, who is your spouse, the right to make that decision, but it's a very hard decision for them to make, and they're not thinking clearly. And there may be someone else in your life who might be in a better position than whoever's highest on that hierarchy to make that choice. Another example is if you're unmarried, but you have multiple children. According to the Family Healthcare Decisions Act, they all have equal priority to make those decisions for you. And again, one of them may have differing religious views than you do, which could affect the choices made in your healthcare. They could have different views based on what treatments to give or not give, or they could just fight amongst each other and then no decisions are being made. So again, in a time where you're unable to control exactly what goes on, you're at least able to assert some sort of control because you have designated the person that's going to be your mouthpiece in advance. And you have put that person in that role, and hopefully you've had those conversations so that person knows how they should be acting. The other document that we often sign with clients is called a living will. A living will is a general statement of what your wishes are regarding if you're in an irreversible state with no hope of recovery, whether or not you would want certain treatments to be withheld or withdrawn. Again, we're referring to cardiopulmonary resuscitation often, kidney dialysis, cancer treatments, antibiotics, feeding tube. And these are all the kinds of decisions that you're going to want your agent to make. But this document is how your agent has more evidence of what your decision would be if you could speak for yourself. So for example, many clients want to sign a living will that says, my agent has the right to withdraw or withhold all of these certain treatments, and it lists them out, because if they're in a position where the doctors say that I'm in an irreversible state with no reasonable expectation of recovery. And that living will is going to be backup for your healthcare agent in case somebody disagrees with them about what your wishes would be. And it's also going to be a guideline for your agent and help for your agent, because this is a hard decision that you're asking other people to make sometimes. And having these ancillary documents to guide that agent is going to help them to better make a decision and feel comfortable and at peace with the decision that they have made. The other document that I want to refer to, which isn't necessarily done in advance, and in many COVID situations, is not the most helpful, but it's a MOLST form, MOLST, Measures of Life-Sustaining Treatment. This is a form that is actually signed by the individual and their physician, and it is a physician's order, and it has more specific information about the person's wishes about when to be taken to the hospital, when not to be, what interventions to be given and not to be given. And this is usually done for people who are at a more terminal phase or have a more negative prognosis, or a diagnosis where they have an idea of what the treatment options are going to be going forward. And again, this is a way for them to control if it gets to a point where they can't voice what their wishes are anymore. The next document I want to talk about is the power of attorney. I talk to people all the time about the importance of the power of attorney. And again, people young, people old. And in this time of the pause in New York State due to COVID-19, what we've learned is that there are many circumstances in which some people who were high risk, they may not have been unable to access their finances or handle their financial matters because they were sick or they were in a facility. For some people, it's just that they were being safe and they were sheltering at home because they were in a high risk category. And because of that, they need others to do certain functions for them within the financial realm. So I'll give an example. I spoke with a family, and the father was looking to purchase a property. And back at the beginning of 2020, he found the property and located the property he wanted to purchase. But as it got closer to the closing date, the New York pause happened, and he was unable to attend the closing, and somebody had to attend on his behalf. And so he had a power of attorney in place. And so the family member who was named as agent under the power of attorney was able to appear at that closing for him. That was very important. He was not sick from COVID, but he was in a position where he wasn't able to attend the closing. And so he didn't have a lack of capacity, and the power of attorney doesn't require that you have a lack of capacity, but it'd be a lack of ability to attend. And so the power of attorney document is a document that is going to allow somebody to access your bank accounts most often, depends on what powers are given, do real estate transactions, sign contracts, access a safe deposit box, make transfers to trust, create a trust, all sorts of different functions to do with your financial needs. And so again, during COVID, what we've learned is that there were a lot of people who weren't able to handle the day-to-day business of their lives because it was unsafe for them to leave their homes, and they had other people acting on their behalf. And so this was a really great time to have a solid power of attorney in place in case you needed somebody to do things for you. I talked about if you don't have any healthcare proxy, that the Family Healthcare Decisions Act would pop into play, but I want to point out that that's only if you're in a facility. So if you were in a facility, then that works. But if you're not, if you're at home or otherwise, there is no default in the law for who will act as healthcare agent. Similarly, if there is no one in play as the power of attorney, then there is no backup if you don't have that document. So it's very important to realize that, for example, just being a spouse is not enough to allow you to be able to authorize and access the bank accounts and other assets of your spouse. You do not automatically have that power on solely held accounts unless you are the power of attorney. Now, obviously, if the accounts are joint, then both persons who are joint on that account have access, but it really becomes an issue when the assets are separate in any way. So what do you do if you don't have that financial power of attorney? Well, then we often look to a point where an incapacitated person will need a guardianship. Somebody will have to petition the court, the Supreme Court in New York, and ask for a guardian to be appointed. But another thing that we found out during COVID is that in situations like this, the courts are closed. And while they are hearing emergency applications, it is very difficult to navigate how to actually file the paperwork for that emergency application, and also how to make sure that the person that you're saying should be declared incapacitated, how do you make sure that person has due process rights and has the ability to fight it if they don't want to have a guardian appointed for them? And so the courts are really having, every courthouse and every county is a little different in how they're handling this. I have some information that as the courts are coming back online right now, they're coming back and people are coming back into work, but they're phasing them in. They're there on a limited basis and there's a backlog. And so you really don't want to be relying on a guardianship. And normally I would tell you, you don't want to rely on a guardianship because of the cost, because of the delay, because of all of these things, the extra oversight of the court, if you could just have a power of attorney. But it's even more so in this time because the courts are not open and the courts aren't able to assist people as readily as they usually are. And so it's really important, again, that you have these designations made because the defaults are not really fail-proof. The defaults aren't going to be good enough here. We also had somebody who asked a question about, when we talk about these documents being for people of all ages, they're for people of all ages and all abilities. As long as somebody has the mental capacity to understand the power that they're giving to another person and understand the nature of that, then they are a person who can sign one of these documents. Of course, you have to be over 18 years old. But specifically, we had a question in advance of this webinar about somebody with special needs and if they should be signing a power of attorney or a healthcare proxy. And my answer to that person would be that if your loved one has the ability, the mental capacity to understand those documents, then certainly they should be signing them. And if your loved one does not have the mental capacity to sign those types of documents, well, then you should be seeking guardianship over that adult so that somebody is empowered to make those decisions at these times when it becomes necessary. I think we have a question, Liz, if you want to read that.
Sure. My mother recently set up a revocable, but has yet to fund it due to sheltering in. I am a trustee of the trust and have her power of attorney. With her permission, can I go to her banks and fund her trust without her being physically present? Do banks typically accept the power of attorney for this purpose, or do they need my mother to be there as well?
That's a really great question. So basically, this person, their mother was part of the way through their planning, created a revocable trust, but nothing's in it. This is a really big problem that people create these trust documents, but then they don't realize that the further step that's necessary is to take accounts and take assets and title them in the name of the trust so that they're actually in there. And that's a really important step. And it looks like this person was about halfway through when they got to a point where they weren't able to go to the banks on their own. A power of attorney gives the agent the powers that it states within the document. So that this person is saying they have the power of attorney. Are they able to transfer the assets from mom's name into the trust name? And I would say to go back to your power of attorney document and see, does it give you the power to fund trust? And usually that's in what, if it's a power of attorney that was signed after 2009, that's in what we call the statutory gifts rider. That's actually after 2010. From 2009 to 2010, it was called the major statutory gifts rider. But as long as that gifts rider has the ability for the agent to make transfers to trust, then that should be sufficient. But the actual steps are going to be that step one is that the banking institution that has the account that you want to transfer needs to get a copy of the power of attorney. They'll probably need to send it to their legal department, which is probably going to be out of state or certainly not on premises. Once the legal department reviews that power of attorney and finds that it's valid, they can then put the power of attorney on the account, and you'll be listed on the account as power of attorney. Then once on the account as power of attorney, assuming the document allowed you to make those transfers, you can then retitle them into the name of the trust. And the question was, do banks typically allow an agent under power of attorney to do this? And with a revocable trust, I think that you're going to find it's easier than with an irrevocable trust. But yes, the bank should allow it. Now, I'll never promise that a bank will let anybody do anything with the power of attorney, because you never know what you're going to come across when you get there. But legally, you should be able to do so.
Thank you. Next question. Should retirement accounts, for example, IRAs, Roth, pension plans, be a part of a living revocable trust?
No. Those accounts should stay in the individual name of the owner. You don't want to change those into the name of the trust. One, there's not really a benefit to doing so. You'd be better off naming the trust as beneficiary or naming individuals as beneficiaries on those accounts. However, I will caution that when you get into naming beneficiaries on these types of accounts, especially if the beneficiary is going to be a trust, that you want to seek the advice of your attorney to make sure that the trust is written properly to do so, and that you're not creating a tax problem for those beneficiaries. There were big changes in the law in December of 2019. It's called the Secure Act, and that's really changing how beneficiaries are to inherit those types of accounts. But they will not get titled in the name of a trust during the lifetime of the original owner.
Thank you, Britt. I don't see any additional questions.
Okay, great. Well, I want to thank everyone for joining us. This has been, as we go through these webinars, I hope that everybody's learned a lot, and we're gonna keep learning and keeping out there to show you the information that you need in order to make sure that you're taken care of, as you move forward, you and your loved ones. So I hope you all have a great day, and we will talk to you soon. Thank you.